SSTI Board of Directors, and we're collaborating with Najid in this YouTube series. We have here Steve Mines. He is a federally certified interpreter, and he's also a conference interpreter, a Najid certified interpreter, and an attorney. So we are here today for new interpreters or those of you who want to become interpreters to tell you a little bit about the stages of a trial. And I'm going to let Steve take over now.
So I was thinking, Janice, of what would be of interest to a new interpreter or somebody interested in working in court as an interpreter, and thinking that maybe they aren't as familiar with what all is involved in a trial. And from the perspective of the interpreter, I say, broadly speaking, there are three periods of time, three stages that involve different aspects of the interpreter and their skills. Before the trial ever starts in the courtroom, the parties will prepare documents. Some of those involve translation and interpreting. But really, the first stage that involves an interpreter is the selection of the jurors. This is, for me, one of the more exciting parts of the trial because it's very unpredictable what citizens will say when they are brought together to be chosen for a jury. As we know, the reason to select a jury in this way is to eliminate any bias against or in favor of the parties. And those questions that are asked by the court, by the judge, as well as by the prosecution lawyers and the defense lawyers are always interesting in that you never really know what people are going to say. And you have to interpret all of that for the benefit of the defendant so that they can help their lawyers choose and eliminate anyone that they don't want to be on the jury, to the extent that that's allowed by law. Then, once the jury is selected, and the word is impaneled, they're sworn in, then the interpreters really go to work on kind of more formal speeches. The first part is the opening arguments. Both the prosecution and the defense get a chance to make opening arguments. They're sort of a foretaste, a little quick review of what's going to happen. And by quick, I mean it could be 30 minutes. So it's heavy lifting for the interpreter to be prepared because you can hear all kinds of pop culture references, biblical references, all the kinds of things that lawyers will try to bring to set the stage for the trial, but also to make themselves very personable to the jury and, in the case of defense attorneys, make their clients, the defendants in the case, also likable and approachable for the purposes of the trial. Once the opening arguments have been made, then the prosecution begins their side, and that's the case in chief. And that involves the testimony of witnesses, and through the witnesses, the presentation of evidence, which could be, as far as the interpreters are concerned, interpreted evidence from the witness stand. It could be written document evidence that should be translated ahead of time, but surprises can happen, and jurors should, and interpreters should not be asked to interpret on the fly complex documents that should have been done ahead of time. But that can still happen. Or recordings, audio testimony, transcripts of recordings, they should have been prepared ahead of time. As far as the interpreter is concerned, you shouldn't think that you can uphold your oath to interpret accurately doing something that you weren't given a chance to prepare ahead of time. Then, once the prosecution's case has been presented, the defense may or may not decide that they're going to present evidence. In our U.S. Justice system, a defendant is not required to speak in court and may just remain silent and leave it entirely up to the presentation of evidence by the prosecution to prove the case before the jury. But witnesses and evidence that are presented by the defense also require interpretation, and certainly the cross-examination of witnesses is one of the trickiest parts for interpreters because the way that lawyers will ask questions on cross-examination is sometimes intended to trap a witness into giving evidence that is unfavorable or that will show why the jury should or should not believe the other side. And then finally, when all the evidence has been presented, The last part involves the jury instructions from the judge. And that's usually a quite convoluted and involved written document that is read sometimes at a rapid speed. The interpreters have to follow that. So the best idea is to get that a day or more ahead of time and be prepared to do that.
I think we skipped the closing arguments.
Oh yes, you're right. Before the jury instructions, the lawyers, both for the prosecution as well as for the defense, may repeat some of the information. Really, it's a review of the information, because the trial could have lasted a few days, a few weeks, or longer. And so this is a chance to sort of refresh and remind the jurors of what that side has tried to prove, and why the jury should rule in their favor. Then, you're very right, then the court gives the jury instructions to the jury. That is also interpreted for the defendant, if the defendant has interpreting. And then the jury retires to deliberate. During that time, the interpreter gets to rest a little while, usually, and wait for questions that may come while the jury is deliberating. Those have to be interpreted as well for the defendant. And finally, the more solemn, but usually very quick part of the trial, which is the verdict, read by the foreperson of the jury and interpreted as well.
And there you have it. These are the general stages of a trial. Thank you so much, Steve. And if you want to learn more about NAJIT, please go to najit.org. Thank you for watching.